Our next panelist is Péter Kruzslicz from the University of Szeged, who will deliver a lecture with the title "History in, by, and for Constitutional Law: The Role and the Place of History in Hungarian Constitutional Law."
Thank you. So, dear colleagues, dear friends, first of all, of course, it's a pleasure to be with you again. I say again because we met already for the research group in June. I have prepared something that I found interesting and in relation with our original research topic, the protection of national, state and community symbols. I know that we are at the end of the afternoon and we had many speakers and presentations today, so I will try to be as indulgent as I can be with you. And I would like to start with a personal approach in order to make you relax a little bit, because I have to admit that I have participated to 3 different research projects with relation to history. That's why also I have decided to speak a little bit about it, because I'm not a historian of law. Actually, it was one subject that I not really liked during my years at the Faculty of Law at the University of Szeged. I won't mention the name of professors. Their souls are resting in peace now. I think you know what I am speaking about. But I found back my way to the history of law, once again because of different research projects. On one hand, we had this research project about symbols, and of course, as I have developed in the chapter that I have written for the book, historical narrative in constitutions has important role as symbols in constitutions. In Hungary, we have some specificities. You have heard Professor Schweitzer this morning about Holy Crown historic constitution. Also, I was working for another research project which was about past, history, memory, and constitutional law. And I think it was a very interesting question that we raised for a roundtable, annual roundtable that we have in Aix-en-Provence at the University Aix-Marseille about constitutional justice. How past, history, memory, those are 3 different things but closely related, appears in constitutional case law. And the last one, and actually I have brought the image, was about the 800 year of the Golden Bull Aurea, the Hungarian Magna Carta, if I may so, that we celebrated last week in Brussels. So this was not a research project, actually, it was only a conference. I have participated to the organization, and I could admire the copy of the document. Actually, the original was lost, if I know correctly, but we have 17 authentic copies of the document, and one is at the Constitutional Court of Hungary, and this one was exhibited during the conference in Brussels. So it was quite an interesting document, and I brought you the image. But I don't want to speak about, of course, this historical document. I would like to speak about, as I have mentioned in the title, this question of history in constitutional law. And actually, I think that there are 2 main problems. I call them methodological because I have no better term to describe them, but those are not only formal, those are also substantial problems when we would like to get closer to historical questions, to say so, in the framework of the constitutional law. On one hand, I wanted to refer to this research project that I was working on during summer about the question of past, history, and memory. I don't want to go too much about those questions, but I think it's quite interesting, and I had the chance to discuss it more in details with some colleagues coming from different countries, that of course we have a past. The past is an experience. It's very difficult to describe that past by historiography, but of course historians, they have their own method to describe the past. As one French colleague said, I don't remember the exact quote, but in order to re-establish 1 hour of past, we need several years of study, of course. So this is the task of history. But history is not reflected directly in a constitution. A constitution brings up something by the historical narrative, as I would like to show you briefly, what we can call a national myth, what we can call a historical narrative, what we can call a kind of memory about the history, about the past. And of course, those three are closely related as circles, however, by nature, they are different. On the other, but this is the classical problem about history, you have, of course, those three entities. You have the constitutional law that we apply, the constitutionalism that we protect. You have, of course, national history, a historical development that is behind a constitutional law, and you have theory of the state, of course, and those are closely related. I mean, there is an impact from one to another. So the way that we think about the state can change our history, and our history can change our constitutional law, and it goes back, of course, just like the other dilemma, but this one, I think, it's very well known. As Professor Schweitzer already mentioned in the morning, history and past is all over the fundamental law of Hungary. You start to read the fundamental law of Hungary, and you will find a lot of stuff, to say so, about history, about the past. The one that I brought, that I wanted to bring into your attention at the beginning of my presentation is a question of definition. Because if you read the national avowal, which is the preamble of the fundamental law of Hungary, you can find a very interesting definition what a constitution is. On one hand, of course, you have the classical definition. Fundamental law is the basis of the legal order of the country, so nothing very revolutionary as an idea in that, but also an alliance among Hungarians of the past, the present, and the future. So here you have this intergenerational bund that we would like to create by a constitution. I think this is a first step where the past, as the past, not as the history, comes into our attention when speaking about Hungarian constitutional law. But once again, a lot of references to time, to past, to history are all over present in Hungarian constitution. Here you have some quotes that I've found in National Avowal, that I called in my chapter also historical narrative that we have in the National Avowal. My colleague will tell you more about those. I don't want to read all those quotes now. As I have established, on one hand, that is a question of symbols and symbolism. On the other hand, it's a question of creating identity for a political community. So there is this identity creating role. This is how history appears in the Constitution. So the first idea in the Constitution, we have a historical narrative, which is once again not surely about past, but neither about historiography. It's more about a national myth. Then, I always go back. I don't know why I speak about the past, so I always would like to go back. The most important question that I would like to highlight in today's presentation is the question of how we use, misuse, or abuse of history or something that we consider historical for the protection of constitutionality. As I will also mention by the end of my presentation, the basic idea with the Hungarian fundamental law that historic constitution should be a guideline for the interpretation of the fundamental law. I will come to that, so it will be a kind of source of constitutionalism, but not the historic constitution, neither the norms of constitutional past, but something that we call achievements of historic constitution. But before that, I wanted to highlight how we think about this question of history by the constitution, or for the constitutionality, to be more precise. I really like to quote the decision of the Constitutional Court going back to 2012, when the first time they used in the motivation of the decision the idea of this historic constitution, and actually the court said that this is a historical responsibility to speak about historic constitution. To go a little bit more serious, I do agree, and also I always quote Professor Bónis, who was a very famous professor of history of law at the Szeged University, who actually asked all the colleagues who deal with history and constitution to be very vigilant. The sentence that he used was that often Hungarian lawyers, it was written the article in 1942, so it was before a written constitution for Hungarians, and he said that often Hungarian constitutional lawyers think about themselves as they have been made knights of the constitutionalism by the sword of Andrei II, the king who promulgated the golden bull that I was speaking about. There is a danger of anachronism. There is a danger of willing to go back to history when we deal with those questions, even when we were under a historic constitution, because Professor Bónis said that under historic constitution, to pay really attention how we use ancient norms for the protection of constitutionality. Actually, the Hungarian Constitutional Court, when they refer to historic constitution, they use some modern constitutional principles: independence of judiciary, parliamentarism, freedom of expression, ne bis in idem. I could give a long list of different principles when they used the idea of historic constitution in order to strengthen their motivation. There is also an interesting question, but we have no time to go in further details, about the protection of a Hungarian way of constitutionalism, which could be, I think, a little bit more dangerous for this idea about constitutional identity, which would be the fruit of a special development of constitutionalism. Over there as well, I think often to the same Professor Bónis, who said that every European nation think that its constitution is special. But how it is special, very difficult to say so, as a constitution is by definition a question how we create balance between the national power of the state and the freedom of individuals. I didn't quote it word by word, but this was the basic idea. And by the end, I would like to highlight, sorry, I go always back. It should be an illness. How we brought up this historic constitution. So this is not a constitutional history, there is a difference, but a historic constitution that we would like to bring back with fundamental law, as Professor Schweitzer already quoted this article of the Hungarian fundamental law. We can read: the provisions of the fundamental law shall be interpreted in accordance with their purposes, the national avowal contained therein, and the achievement of our historic constitutions. So over there, the huge question is, and I will finish by that. I think I respected the time, or almost
5 minutes.
5 minutes. I have 5 minutes. Okay, then I can go. 4. Okay, perfect. So because 2, 1, and so I think it's a very interesting question, because I think that there are two logical gaps, to say so, in the sentence. you can read it that we don't want to use historic constitution as it is. It's not a question of the application of a historic constitution. We would like to have something that we call achievement of historic constitution. It's a very difficult question, how we can define those achievements. According to my professional point of view, because those are achievements, it's up to the Constitutional Court to decide about what the judges are considering as achievements. However, when we decide about such a question, you of course have to motivate your choice, which is something that should be related for historic constitution. And once again, historic constitution is not the same that constitutional history. Also, it is not per se a source of constitutionalism. Not those achievements should be in use in order to define where are the limits of the constitutionalism in the national legal order, but they should be something like guidelines for the interpretation. And once again, a very difficult question. Many authors already tried to answer the question, so no need for me to try to answer it. But a very difficult question, how you define those achievements and how you can use them only as guidelines for interpretation. Actually, the fact that you have to use them as guidelines, I think, has a very important impact on their definition. Because you need something that you can use as guidelines when you would like to define what are those achievements of historic constitution. And you know, not only we have this problem of historic constitution, but we have another very interesting question, and I will finish with that. Also, Professor Schweitzer mentioned in this morning the question of Holy Crown. In Hungarian constitutional history, or in our constitutional heritage, we have this kind of questions, and Professor Schweitzer mentioned all the different professors of the history of law in Hungary at the beginning of 20th century who discussed this question. You cannot imagine how this debate was, how to say, same time political but also scientific, a very, very hot question that was in the 20s and the beginning of 30s, what the Holy Crown actually is for a Hungary without king after the First World War. He didn't mention Professor Eckhart among the people who worked about the question, and I think it's very important to mention this name as well after Professor Timun and all the others that Professor Schweitzer mentioned this morning. So I would like to thank you for your kind attention. I hope it was not so painful for you at the middle of the afternoon or by the end of the afternoon. Thank you again.